can you please look up this thing?
See if we can figure out something.
She's not here today. She's under 20 minutes.
All right. Eric Cassidy and Paula Cassidy.
And actually, you did retain a lawyer.
I know. Where is she?
She could not be here today. She needs to go next week. But, you know, we're happy to go forward, but she's available next week. Next Friday.
Okay. Go ahead. Your name?
Donato, appearing on behalf of Alec Jerome and Caroline Jerome, who are the landlords and owners of Route 270 North Maple. In our summons and supplemental complaint, I gave you the numbers that were owing from as of April 15th. I have updated those.
Okay, so
Yes.
I'll just stop you.
Okay.
Did you receive the answer and affirmative defenses?
In the hallway.
They are substantially the same as what was filed.
So
This was dismissed about.
No, I know.
I mean, I've looked through them. They're not signed, and they're virtually the same.
So,
Filed in the case to be dismissed.
yeah, I know. Okay, a couple problems. First of all, you're represented by counsel. They're not here. Okay. That's the first thing. The second thing is, rather than taking a lot of time, I've got another problem with your filing. Okay. You gave a new notice, right? Okay, for 30 days,
Yes.
right? Like we had talked about.
Yeah, it's up May 3rd.
Right. Problem is you filed the case before the notice expired.
I knew that that I wouldn't be heard until after that May 3rd date.
I know, but you can't. I follow what your intentions were, but you can't file. I want to say this. You're giving them 30 days to move out. They have to do something before a cause of action arises. So they either have to move out or some way do something. The problem is that you filed the case before their period in time to do whatever you were telling them to do, which was move out.
Paid as well.
Okay, either way, they had a time period on which to do that. I know they didn't, but you filed a case before that.
It wasn't heard or answered until after that date. So you're going to dismiss this again?
I am not going to do that. I'm saying that's a problem I have. Here's the other problem, the other part of the problem. And I'm not sure where it would end up. If I dismiss your case, their case, the case doesn't go away because they filed a counterclaim and a request for declaratory relief and an answer. So I would have one side of the case pending, right? And I wish counsel were here because counsel would understand exactly what I'm saying. So I'd have the one side of the case pending. I'm presuming that then what you would do is you can use the same notice that you have here, you'd refile. And then what would happen is I would have two cases pending at the same time that I'd have to join together.
Okay.
So if counsel were here, I would suggest to her that she not move to dismiss, waive whatever may come from that, and just keep this going and everybody kind of head into the direction that we're going. Okay. But she's not here, so I can't ask her that. So, you said she's available next week?
Yes, she wants to on Friday.
Yes. Well, they're always on Friday. So what I'm going to do is not dismiss your case at this point. Okay, but that doesn't mean next week it might not happen, right?
We still have.
Well, right, but I'm just suggesting a quicker way to get,
Around
well, not around it, but to get everything moving. And so I'd prefer to give it a week, let that happen, see what counsel says, and then we move. The worst thing that's going to happen is I dismiss your primary claim, you file again. You don't have to wait on the notice because now the notice has expired. And then I'm going to set this other case out until that other case catches up, because that's what I'm going to do for judicial economy. So, got it?
Yes.
I know you don't like it, but it's what I have to do.
I like whatever you can do so that this case does move forward, because the stalling of it has raised it over. Now they want it dismissed because it's over $25,000. Well, that's because they haven't paid anything since September. So.
That is incorrect.
What is incorrect?
Yeah,
Okay,
They've been in arrears.
folks, I cannot litigate this today.
No, I know. I'm not unhappy, and I'm not, I'm very pleased that you are able to create a way forward.
Let's hope. Okay, well, you're welcome for that. May 17th, 2024, what time?
2 p.m.
At 2 p.m. We'll see you guys then.
Just there's no one did file a very short other issue that she has retained. It's with your file, and so
She did what?
she filed,
I know, she gave me a whole tree.
yes,
So what,
on the inside, it lists 5 different issues that she wants to fix if you want. And she also filed she wants to inside cover.
got it. We'll see you guys next week. Case of Alec Jerome versus Eric Cassidy. To be Eric Cassidy and Paula Cassidy. Go ahead.
Donna Tope appearing on behalf of Caroline Jerome, who is watching by Zoom. I recognize Caroline.
Okay.
And Alec Jerome. They are the landlords in this.
Got it. All right.
Your Honor, Frank Silver appearing with Eric Cassidy. Ms. Cassidy, Paula is not well. She's been undergoing chemotherapy, and so she won't be present.
All right. Very good. All right. So where are we now in this case?
So appeared before you, and I have on the results of that hearing. I got their counter complaint, et cetera, and I have filed a complaint bringing the non-payment amount that we are requesting for judgment up to date. And it was.
Hold on a second.
I filed a complaint on Tuesday, and we've been given a case number, but I would.
Hold on a second.
Okay,
You filed a new complaint.
yes, you advised me that the complaint that I had made it
Okay, go
so
ahead.
that it would be heard. I gave them more than 30 days to get out. I had that complaint to be heard on the same date that they were supposed to either pay or evacuate. You said, no, I needed to, because my 30-day notice was still good. I refiled on Tuesday and I received a new case number. And on that summons and complaint, I noted that there is this pending case because they had filed a counterclaim. And you set this hearing for the counterclaim because
Well, no.
Mr. Cassidy's
No, no,
attorney.
no.
Okay,
The last time we were here, I was indicating to you what were, as I'm recalling, were distinctions between the notice and the complaint. And basically gave an option that if I dismissed your complaint, what would end up happening is their counter complaint would survive.
Mhm.
And so therefore I'd have a case that would just have a counter complaint. So you filed a new complaint.
and I would guess that I would like,
That's fine.
I'm asking for, I asked for the file.
Thank you. You read my mind.
I-
Did they open it?
It is open.
Okay. They're bringing it.
Except for next Friday.
Got it. Okay. Go ahead.
okay, so I guess an order of administrative business, would I request now a motion to join that complaint, or do I need to file a motion to join that complaint with the counter complaint?
Well, here's what's gonna happen. I'm
Okay.
gonna hear them all at the same time, whether they have two files or one file.
Got it.
So you can file a motion for joinder if that's what you wish, but I
Okay,
don't know that necessarily matters. How much are you claiming
okay.
is owing in rent?
I would like to, I just make a statement. This case is a simple non-payment of rent case based on the agreement to pay rent and utilities for 102 weeks and follow the simple rules stated clearly in the lease and accepted by the defendants. We want $25,891.07 in unpaid rent. Defendants have been in arrears since September 1st of 2023. That's 9 months. And they
Okay,
have
ma'am,
paid
ma'am,
nothing
ma'am,
since
ma'am.
December 2023.
Counsel, please.
Okay,
So the first thing, I'm just trying to answer some of the things that are raised that are jurisdictional issues that are raised by the defendants to try to clear the way for that.
okay,
All right. And so because I don't have the new complaint, I wanted to know what your claim was.
okay. The
And so the dollar amount of
the
it.
dollar amount for the rent owing through May 6th is $25,891.07.
Okay, so let me stop you there.
Okay,
You can either elect to proceed to collect 25,000. Or you're going to have, this case is going to have to go elsewhere. Which I say won't necessarily make me unhappy. I don't know, I shouldn't have said that.
does that terminate the lease or does that get the lease paid up to now? Because the lease goes for 102 weeks.
No. I have jurisdiction to 25,000 on most civil matters. There is some case law that indicates that I can exceed the 25,000 because it's a landlord tenant matter. But I have to have argument on that in any event. Or what you can do is you can elect to limit your claim to 25,000 and it would stay here. Otherwise, this matter has to be transferred to circuit court.
Okay, so to keep it here before you, that's the first thing, right? To accept.
That I couldn't, you need to understand, I could not issue a judgment or would not issue a judgment
Okay,
for an excess of 25,000.
okay, so we can
Plus
claim
cost.
that, but in order to have it heard by you,
Or
you
in
would
this,
only, yeah. So you're telling us that that's all we're going to get if we
if it
continue.
stays here, that's all that I can do
Okay,
or will do.
okay. Well. glad you're consistent.
Pardon?
It's not printed or like the paper. JS copy.
There isn't one, but that's all right. I'll be all right. And
So,
Ms. Novart, hold on a second. Ms. Novart, is there anything you wanted to say on that $25,000 issue?
Yes, Your Honor. Is it okay if I
Yeah, you can say that, that's fine.
Your Honor, my clients are asking for a $2,000 a month abatement of the rent because of numerous things that were never repaired, that were promised to be repaired. So that almost gets us right there to the $25,000, maybe a little short of that, but our counterclaims will far exceed that. My clients have been retaliated against, they've been falsely accused of harboring illegals. They've been spied on, their property was wrongfully entered by Ms. Toe by numerous occasions. She's called the police on them. She falsely accused my client, partner in a law firm in Houston, of assaulting her. So our counterclaims will far exceed the $25,000 jurisdictional limit.
Okay, so if you attach an affidavit to actually, you don't have in here, I was trying to make sure I go through everything, but you don't have you didn't file a motion to remove the circuit, did you?
Yeah, we were going to do a motion on the record today, Your Honor, if we need to file.
I think there would need to be a written motion with that, with the accompanying affidavits that would be necessary for the court to, because of the way that your counterclaims are stated, there would have to be an affidavit indicating that. Okay, so now here, given that that's going to be their position on the counterclaim, that means well, you just can't make this easy. So that means the entirety of it would go. All right.
I did have a suggestion.
Well, before you do that, I'm
Okay.
just trying to procedurally think this through. So I'm going to have to take back what I said, because if it had remained here, I'd just operate with two files and wouldn't care. You would have to file a motion to consolidate this new case with this case. You'll file your motion to remove it so that everything goes. Because otherwise what will happen is, I would imagine that once they file theirs, it will go to circuit. Your case will be remaining here, which I don't know. Doesn't make, that wouldn't make much sense to me, quite frankly.
Right.
All right. I would indicate to the parties this, because I don't know why I'm doing this, but what the heck. The other way to go around this would be if the parties were in agreement and wanted sort of a quicker process. Is that, and I've done it before in the past, I don't know that I really want to do it here, but I will. And that is that if both parties would agree, I would then talk to the chief judge of the circuit court, have myself appointed as a circuit court judge for the purposes of this case, and have it resolved here, and I could hear all claims. But both parties would have to agree to that before I would do that. It'd be the same process. It's just that, quite frankly, with landlord-tenant cases, I have no offense to my circuit court colleagues, it's what we do here. So,
Yeah.
Your Honor, would the circuit court rules apply in a case like that if you were to hear it? So all the rules of discovery and evidence and the timeline.
the discovery, everything happens as though it's circuit court. So in district court, there would not normally be discovery until the court says there's discovery. In a case like this one, I would have ordered discovery in any event. But what will happen is that you will have those you'd have the discovery and the like.
So if I had gone through this, one of the things that I was going to posit is that if they pay the rent that is owing to date, the lease will stand as it is for 102 days and mediate the remaining issues, which are what she is propositioning, that, there's been wrongdoing on the landlord's side to the tune of $2,000 a month, and then adjust everything once mediation and case evaluation and all that takes place.
Well, I'm certainly not going to speak for Ms. Nover. I'm sure she could speak for herself, but it seems to me that their idea is that they don't owe anything, ultimately, right? Or something, but much like.
Depending upon the time frame, there were certain times, at some point, it became owing nothing because of the blatant refusal to do anything. Originally, we were going to ask for an abatement because of major things like air conditioning, central air, which was promised was never fixed, the oven stove isn't working properly. So it may end up to several months, we will ask for no rent at all, but for several of the months an abatement.
Gotcha.
The home has been not without air conditioning and not without heat.
Well, hold on, because
Well,
I can't.
okay, but you're taking into consideration abatement for things
I'm
that
not taking I haven't taken into consideration anything. I just sat here, hold on. I just sat here and said that I'm just trying to figure out procedurally how you guys are going to hear the case.
I would like to do what you're suggesting. I would like to keep it before you. Landlord tenant, you have such experience with it, and that's what this is. This is simply a landlord tenant case.
All right. And Ms. Novar, do you have a position on that? And if you want it to go up to circuit, I am not, but by no means will I take any offense whatsoever. I will be more than happy. I will carry the file there myself.
That's where I usually work, so I'm very comfortable in circuit court. However, my client and I would like to discuss that. I think what we'd like to do is wait for the written motion to consolidate the cases, and then we'll have an answer for you then at that point. And we would do, at that point, we would probably do a motion to remove, but we would let you know if we agreed to have you hear that versus.
Okay, and so that you also know, just because this is the other kicker to it. It could get sent up and then come right back
Yeah,
because
they know.
just so that
No.
you know that that has also happened where I get the call from the circuit court saying,
I see.
This is.
here this.
Yeah, I understand that, but a number of our counterclaims are really much more better situated in circuit court where the judges have had experience with the numerous counterclaims that we have. So,
Well,
I don't know.
I think you should understand that I've heard circuit court cases for 25 years. So I'm just saying, it's more the landlord tenant aspect that isn't there.
Right.
But I mean, I am more than happy to send this case out and then let it fall where it may. It's not like I don't have stuff to do.
Here.
Your Honor, may I say something else just in general? We've tried on numerous occasions, including 2 days ago or yesterday, to ask, I asked Ms. Tobin an email, if you like to allow the parties to mediate. Can you order the parties to mediate pending the motions that you're about to hear that will be filed in this case regarding the consolidation and the removal? Because the lease requires it. So I'm hoping the district court, with their somewhat equitable power, little equitable power.
Well, no, we have equitable over landlord tenant. I have full equitable power. So.
So the lease requires it. We've tried repeatedly to ask for mediation and we keep hearing no, but the lease requires it, number one, and that could possibly resolve everything.
I would like to speak to that point.
Sure.
Thank you. Our lease does require it through the University of Michigan Mediation Center for Students. Paula Cassidy was a student at the time we signed the lease. They did not go and utilize that term that we welcome in our lease. They went instead to Student Legal Services and had Mr. Lewis represent Paula and appear as her attorney. They absolutely closed the door on mediation.
Can I ask this? Because history is fine, but I don't know that I need it right now. I think what I'm hearing from the defendant side is they would wish for this to be mediated.
Yes, and I am telling you why I have told them no, because they closed the door on that. If we can hear the unpaid rent and utilities, then mediate the rest.
Ma'am, I don't know. I don't know what happened before.
Right.
Right? All I have is what's in front of me, which is quite frankly a lot. What I'm hearing from Ms. Novar is they would wish the case to be sent to mediation so that the parties mediate. Okay? Regardless of what's happened before. The question then becomes, are you amenable to mediation? I will say also that I can order it to mediation. So, I mean, I typically don't because I can kind of waddle through what needs to get through and sometimes I can handle it faster than getting mediators set up. But are you willing to mediate it or no?
We are willing to mediate, but only on the things that they claim should result in abatement. We have rent that has been unpaid. It's caused a hardship for the owners and the landlord.
Okay, so here's the thing. And I guess maybe you should look at it this way. What you have are what are really going to be sort of these firm contractual numbers.
Yes.
Okay. There's, I don't really want to call them soft because I think that's not the way to really look at it. They're going to have numbers when they're talking about abatements and other things, which are the sort of softer side of and sort of dig into those hard numbers.
Right.
So you can't, it's impossible to separate it out. So there, for example, there would be no way I would take your claims of those hard numbers of, just adding up each month, let that sit there and then send everything else to mediation, because I don't know what then they're mediating against or mediating with. Does that make sense to you?
It makes perfect sense to me, but meanwhile, the owners, landlords have been without utilities not being paid. We pay the utilities. They have not reimbursed us under the terms of, so, I mean, can we get partial payment and have the abatement amount that they're saying withheld from the payment partial?
How would you, okay, let me just answer.
I'm just
How
trying to
would
get something.
you, how would you expect me to do that?
I don't know.
Because here's the only thing that I could do. But I could do this, but it doesn't help you. I could order escrow. They could pay into escrow, but it's gonna sit here
Yeah.
until such time as whatever's resolved and the court orders the escrow split. Now,
Our greatest fear.
but hold it, the only exception to that I've made over the years is when something's not paid that jeopardizes the property itself. Then I will order paid out of escrow those funds to preserve
No,
the
the
property.
perfect condition.
But other than that,
Period.
I mean, so the bottom line to it is, if the parties want mediation, it all goes, or none of it's gonna go. Because it doesn't make any sense to do it any other way.
And Your Honor, one of the reasons we want mediation, honestly, is because I feel that, in all due respect to Ms. Toth, that she's been an impediment to settlement. And so I feel if we can get the landlord at the table with the tenants, we have a much better opportunity to settle the case. Not to mention the fact that it is required in the contract that both parties sign. And Ms. Cassidy is still speaking to you about.
Okay. We wrote a really great lease. We had mediation in it. They withheld rent for no given reason. I would, and either party can, under our lease, either party can request mediation at the University of Michigan. If we go to mediation, I will utilize that part of our lease.
If you what?
If we decide, if we agree to go to mediation, I will go to the University of Michigan's mediation that is part of our lease, instead of, looking for someone outside to mediate.
Just to clarify, Your Honor, the lease calls for Michigan on-campus housing program to do the mediation.
Is that who you guys want to do the mediation?
I mean, I know a number of good mediators.
I'm not paying a
mediator.
mediator.
If they're limited to, then that's fine. We would agree to do that. We're required, in fact, to do that.
What do you want to do?
Oh, sorry, what was the question?
Well, I'm asking what she wants to do.
I think I just said what we would do. I would agree to mediation. I will go to the University of Michigan. I'm not paying a mediator.
And you're agreeable to that, or believe that you may be bound to that?
Yes.
So, if that's the case, do we think that the parties can stipulate to an order sending it to mediation?
Yes,
And then in that order, and so you would send both these cases to mediation. The case at this point, and I like Snovar's idea, the case would stay here. Okay. And I just think in the stipulation to send it to mediation that neither party is waiving any right to remove the case. That issue is not being addressed, but it's being sent to mediation. So then you guys can have that fight later down the road.
could this be folded into a stipulation to consolidate the cases and agree to mediation under the terms that you just said, so we don't have to have separate motions?
Ms. Newmeyer, it really, if she moves to consolidate, are you gonna have an objection to the consolidation?
No, we're not gonna.
Okay, so just, why don't you stipulate to,
We did that step first before we did our motion to remove. I was under the impression of,
pardon?
we needed that step done before.
No, you're right. But I think if it's gonna go this route, if you can make part of the stipulation that you're consolidating these two cases, send it to mediation, doesn't waive your right regarding the
Right.
claim removal, and then we move from there.
But we would like a 30-day limitation if possible, that we need in good faith within 30 days. If provided we
What?
can get to you, Michigan Housing.
What?
I mean, we're gonna limit cases of
Yes.
language.
Hold on. Okay, and what's your objection to what council's proposing?
We have, they haven't paid any rent or utilities, and now we're pushing it on down the road, and we're just.
I think, hold on.
I'm just expressing my frustration. That's,
Well, yeah, and then when I start expressing mine, that's when things get bad.
I know.
So listen, here's
you're
going to be the
patient.
problem. Here's what I heard them say. Okay, so that you understand. What I heard is almost put it on an expedited track.
Yeah, within 30
See-
days, yeah.
Right. I mean,
I get it.
I was surprised actually when it was said, because normally for me, if I send it to mediation, I'm not seeing it for a while. And 30 days is maybe too soon. But anyway.
I
So
think
do
we
you
would
have,
get-
do you have a problem with that?
No, I don't.
mean,
No, I don't.
and
Thank you for asking.
And here is so could do that. And then here is the other part of it. And I don't really like to interfere with anybody's particular position on their cases. I just, let people argue their cases. But man, I'm going to be frank with you, because and then if it stayed here, there's a jury demand, so I think I can say it anyway. The negotiation in good faith
Yeah.
is really going to be clear.
Yeah.
Okay. It needs to be done. Now, I'm going to let you know that when you came in here the very first time, and I get parties start yelling at each other about whatever. But you immediately were trying to sort of convince me what bad people the Cassidys are. Yeah, you were.
I only told you that
Oh,
he physically
ma'am,
assaulted me.
ma'am,
Said nothing about the
Ma'am,
personal.
ma'am, I'm going to tell you how the court was taking it then. Maybe I'm all wrong. And what I'd suggest to you is that as you go to this mediation, that you just take that part out. And that you try to negotiate the case for what the case is.
Yep.
For all I know, all of you are bad people. I have no idea. All of you are good people, but I assume that everybody is a good person until they show me otherwise. But you also have to listen to what their claims are. You don't have to agree, but you have to listen to it. Now, I'm going to tell you this, man, because when Ms. Novard talks about maybe being an impediment toward trying to resolve it, typically with most cases, where that happens is only where you're looking at your side. It doesn't mean that you don't want to win. It doesn't mean that you don't want to come out. It doesn't mean any of that. But you've got to give some credence to what one side is saying or the other.
That's why we have it in our lease.
Yes, but the parties have to do that, ma'am. And I'm talking specifically to you.
Yep.
Because every time you come in and whatever, when the Cassidys appeared here on their own the first time, whatever he was trying to raise, you didn't even hear it. I didn't ask you to agree. You just didn't even hear it. You didn't even hear what he was saying. And if you don't do that, I mean, they're skilled mediators. I get it, but it's going to be a failure. So, I'm going to hope and I'm going to pray that each side is going to do that as you go into mediation, but I don't know. I mean,
It's part of our lease, and in good faith, I follow the lease, and I will participate in mediation with everything that is expected of me as a representative of my clients. I know they want that, and I will do it.
Yeah, can we also remove the May 31st, the second case, the one that was just filed, set for May 31st, move that from the docket?
yeah, I'm taking it all off. Once I get that order, everything's coming off my docket. Okay, but I will have to give a control date. And so how, and that always can be moved, but how long from the time are you looking to have mediation continue? Or what window do you want to kind of give?
I have no idea of what.
Their availability is.
Yeah,
You're right.
But we may pull in another attorney for Paula. We may actually pull in a U of M attorney.
Got it.
That way that may help us.
May help get it there. Okay.
So I'm hoping we can get in within 30 days.
All right, so let's do this. Why don't the parties find out? Let me adjourn this out to the 31st.
Either of us are available.
On the 31st, okay. If people could think they can get everything done in a week, I'm here on the 24th. I'm here every Friday.
We can contact U of M Housing just in general and see if they can mediate, but
Why don't,
take a couple weeks to bring U of M attorney on place.
right, well, why don't I do this? Why don't I set it for next week? Okay. And then you can come back with, and maybe the parties can exchange the stipulation regarding mediation. See where we are. If we run into a hiccup, then I can try to deal with that. And then at least if the call is made, then at least maybe you can have a framework as to, and then we can sort of guide ourselves that way. I think that might be it.
That sounds good. Would you be able to do that appearance by Zoom?
I don't see, if we have the paperwork here, I don't see why not. Okay, if you send it to me before then, you can everybody can appear via Zoom. What time would that be?
3:00.
All right. So set you for the 24th at 3:00. Okay,
Yes, thank you.
thank you. I wrote nothing. And yes, come on. For today's stands in recess. Case People versus Alec Jerome. Eric Cassidy. State your appearances, please.
Donna Tope on behalf of Caroline Jerome, who's via Zoom,
Yes.
and Alec Jerome, the plaintiffs in our case.
Francina providing with defendant Eric Cassidy. Paul Cassidy's not today.
Okay. I thought that the parties were going to come back today with an indication of a framework for mediation through the University of Michigan Housing, or whoever it was. And there was going to be timeframes and the like. Not what I got.
No.
We
So,
thought was about, and we've already done some work to find out and what accommodate our needs.
so you're hearing both our complaint, which is case number 241C1772, and also their counter complaint that is an earlier case. And the thing that I want to know, would like to know first is, you mentioned consolidation. Would that happen?
No. Hold on. What I said is, both of these files are going to come out to me. Whether it be a formal consolidation or not, as long as it remains in this court, I'm it. So, I mean, whether I work out of two files or one, hey.
Okay. Well, so I guess my question is one of procedure. Do you hear their complaint first, their counter complaint, or do you hear our complaint second or first?
Why does that matter for you?
Because I filed a motion for my case.
Let me just shortcut this. I'm going to hear, if I have both files before me, I'm going to hear whatever needs to be heard in an order that makes sense to me.
Okay.
That's how that's going to work.
Okay. So I also filed a statement on mediation.
Oh, I got it.
Okay. So I also contacted the University of Michigan Mediation Services, and I had a very good long talk with my clients who attended the last hearing. And that statement on mediation is what we have come up with. We would like our complaint to be heard as a landlord-tenant complaint for non-payment of rent and termination of tenancy because they have not paid any rent and they have not paid any.
Okay, I get each party has their claims,
Okay.
but are you agreeing? The contract indicates that it will be mediated.
The contract indicates that either party can request mediation, but they did not do that before they withheld rent.
Does it say that they have to do it before they withhold rent? That's not what I read.
You gave me a really wonderful, precise, and pointed statement on good faith. We are convinced that any mediation would not be met with good faith based on all of the interactions that have occurred during the entire time that this situation has existed.
Let me stop you. They request mediation, which I think they have. And as I read the contract, when either party requested, it should happen. What would you, after you get finished saying everything that you're going to say, what do you want me to do?
I would like you to hear my motion.
So what you want me to do is ignore the contractual language of the lease and just do it your way?
I think they ignored the contractual language of the lease. They contacted an attorney and the attorney represented them, Paula, and them at our hearings.
Are you talking about Mr. Navarre?
No, Mr.
Doug,
Lewis.
okay. And
that, to me, was that they were not following the language of the
okay,
lease.
so hold on a second. I don't even know why I'm going through this, because do you want me just to order mediation? Because I'll just order it. And then we don't have to go through all of it. And I thought the parties, when we got here the last time, I thought the parties were going to look into the process of mediation because we were looking at, you wanted something quick. And I think Ms. Navarre said that she would contact and they were going to figure out how fast they could get it. And that's what we were going to come back for. I set this basically as a check to make sure it just didn't linger out there and try to develop a time frame for how this would occur. That's why that's where I thought we were. And then I get this statement basically saying you don't want to go to mediation. And that doesn't make any sense to me because the contract says that. I think both parties agreed that.
Well, I think they voided that part of the contract when they went to an attorney.
My goodness. When they went to an attorney?
They got an attorney. They did not go to mediation. They did not request mediation. I did not request mediation. Either party could request mediation. They did not request it. They hired an attorney and bypassed it. So yeah, if you order mediation, we will definitely comply.
Well, here's what's going to really
happen.
happen. Here's what's really going to happen. If I order mediation, I'll order mediation. Otherwise, what's going to ultimately end up happening once everything's in place, you're going to be in mediation with me, which is just mediation with a hammer. So it's going to happen one way or another. But I guess my issue was I thought that's where we were. And that's now not where you guys are.
Well, we haven't really consulted.
No, I know. When I said you guys, I was not including you. I was not including that side of the room. I'm sorry. Why don't you want to go to mediation?
We have serious reservations about all of the things that have been said to you during the beginning of this.
Okay, everybody has said all kinds of things.
That we're going to be met with good faith. We have serious doubts about that.
Okay. You have serious doubts about that? They, I'm sure, Harris will have serious doubts about that. I gave my admonishment, thinking to both parties, but also based upon what I had already seen here. I gave my admonishment that all the parties should be acting in good faith.
Plain and simple.
And I did tell you that that clause is written in our lease because before anybody goes to an attorney, if there are issues, both parties.
Does it
have-
say that?
It does say that in the lease.
Says
Before
what?
the issues are under litigation. It says,
Okay, the fact that somebody goes to an attorney doesn't mean it's in litigation.
oh yeah, because he appeared at the hearing on my summons and complaint. So that, and we were then sent to you. The lease says, and it's on 37 or 34, no. It says, a mediator can't, if communication between tenants and landlord breaks down. There was no communication. He told me the night before rent was due, he was withholding rent, and he withheld rent since then. And before, if communication between tenants and landlord break down, a mediator can assist the parties in voluntarily reaching a mutually acceptable settlement of the issues in dispute. There were no issues in dispute. We had no knowledge of why he was withholding rent. He just said, we're withholding rent. And he said his wife had retained an attorney.
What is your reluctance to go to mediation?
Gosh, because they have withheld all of the rent. In landlord-tenant cases, only the most catastrophic situation allows for that.
That's not true.
Well, that's what.
That's just not true. Oh my gosh. I mean, no, don't say, oh my gosh. You say, oh my gosh, one more time, I'm gonna find you in contempt, and then
Okay,
we're gonna
I'm
really
sorry.
have a problem. Because that's disrespect.
I mean no disrespect. I'm really saying, oh my gosh, to myself. I'm sorry. I did not intend it for you.
So look, I don't, here's what I don't get. Okay, just from a practical sense. If you go to mediation and the parties with a mediator try to work out whatever the issues are, right? If it doesn't work, you're here. But the issues typically, when cases are sent to mediation, the issues that are involved get narrowed and they get clarified. And that's where then, when it comes back to the court kind of enters into it, and it's much clearer of what you're dealing with. So there's some benefit to it, or can be some benefit. If you're looking for some expedited process, I don't think that's going to happen. I'm looking at this file. It's not going to move. The period of mediation is not going to make this file move any faster here. If that's what you're looking for.
No, we're not. What we're looking for is some kind of financial certainty that you had mentioned escrow, and my motion is to escrow the amount in arrearage. I know you said that you are capped for $25,000 in landlord-tenant cases, but I'm wondering if the arrearage is more than $25,000.
Well,
are you able to?
If you're
escrow
talking
that
about,
amount?
I'm not going to even answer that question. I mean, I'm not capped at the $25,000 limitation. Is really on the money judgment. On the possessory judgment, it can be whatever number. But in terms of a money judgment, that's where the limitation goes in.
Okay, well, I don't know the fine points, and so I was asking if we, in our motion, we ask that the arrearages be escrowed, and if that happens, we would
Okay, so first of all,
participate in
first,
mediation.
no, 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 no. I don't know how you think. I don't know what you're negotiating against. I mean, I just don't. You're negotiating saying, well, they got to do X before we're going to do Y.
Well, if it's held in escrow pending the pendency of the case, and we go through mediation and we come to some kind of an agreement, then what was escrowed would pay whatever we come up with in mediation, which could be something less, and they would get the rest. But how do we just keep adding the arrearages on? This was, 20, close to over $32,000 of unpaid utilities. How can unpaid utilities be mediated? They use them. They lived in the house. They've enjoyed the heat. They've enjoyed the electricity.
You're asking me a hypothetical. I can't answer that.
Well, I get, yeah.
There's no way for me to answer that. Certain things can be mediated. Certain things I think that maybe shouldn't or can't be mediated. They happen to be mediated and have success. I mean, I don't know.
And so we go into June 1st is coming up.
How much is monthly
They
rent?
pay nothing.
A month.
Yeah.
Well, ma'am, first of all, counsel, when you say they pay nothing,
No,
it's not entirely true. If you are requesting an escrow order, I will consider that,
okay.
but not with an escrow order that's in compliance absent certain circumstances, because you're asking me to go back and tell them to put money into escrow. Usually escrow orders, except under the most extreme circumstances, are prospective.
Which they probably should have done instead of withholding all the rent. If they had problems, they should have done that. But
I should have stayed in bed today. I can tell you, they can say you should have done anything. I don't know what you want me to do with that, about what they should have done.
I'm, Your Honor, I'm thinking out loud, and you have been very good. You have been very patient and with your comments that all contain a nugget of information for me when you are telling me that I'm not making any sense and that this isn't, I thought we had it all set.
So that's getting across?
Some things are, yes, it
Okay,
definitely
okay.
is, but so that's what I'm thinking out loud about is the small little crumbs that you have put out that I am trying to follow
Okay, so let me
to
ask
the
you
cottage.
this. Yeah. If I order escrow beginning June 1st, will you go to mediation?
Oh, yes, absolutely. We are
Okay.
so worried about the finances.
Right, everybody's worried about their finances. But she has her hand up. Your client wants to say something. I don't know.
Your Honor, just to say, the reason after speaking to my brother, we resisted mediation is because we had this house, we're very new. This is our first house we've ever rented. And Donna is very by the books, and she insisted that we do everything, and we worked and we got it ready, and we had it inspected. We had it inspected twice and it passed. So when the tenants suddenly started withholding rent and very unclear as to why, then it was a lot of money and it didn't really build the trust between us for mediation. So I think I don't need you to do anything. I just wanted to state that. I don't need to interrupt the court. You guys know what you're doing. But I just wanted to say that breach in trust has really affected this investment that,
No, I got you, but
okay,
ma'am, I'll just tell you, part of the reason I have to do this every day is because there's a break in trust between people.
that's,
So I get it.
yes.
Okay, so
I-
I mean, I get it for various reasons.
All right, I just wanted to say that. Thank you for hearing me.
Thank you for listening.
All right. Ms. Novar, what would you like to tell?
I don't even know where to begin, Your Honor. In addressing the mediation issue, you have been fully informed, but I hear the court going in the direction of ordering mediation, which is what we want. In August 31st of 2021, my client emailed and told the landlord they were owing rent due to no effects. That's in writing. And they told the landlord that they were hiring notice. They've had things not working from day one, etc. Air conditioning is not working.
Your Honor,
So why are you interrupting?
because you did not allow me to address those same things
But
the last
hold
time
it,
you
Ms.
brought
Novar.
them up.
But hang on. You expect me to have Ms. Novar, she sat there patiently saying nothing while you went on about mediation. Particularly, it seems to me that what she's addressing right now is I'll call it an accusation, that they didn't tell you anything and that's why mediation shouldn't happen. I think that's the issue she's addressing. She's saying, look, they told them, and this is what they were talking about the defects.
His email to me said, we are withholding rent, period.
Your Honor, it's our exhibit 4. It doesn't.
I know.
It doesn't say that. Your Honor,
Yes.
this is the strangest case I think I've ever been part of.
Yeah. Well, you should come to my world sometime. But go ahead.
The point of the matter is that our clients withheld rent. They told them why they were withholding rent. Those still issued, and then they paid it in December. They had a family a very tragic event occurring with his wife, one of the tenants. So they had to go to Houston for treatment and surgery. And so they just said, we're gonna pay it. Let's hope when we get back, these things are taken care of. When they got back, not only were the things not taken care of, but now we have a mice infestation. They refused to do anything about the mice infestation. They called Terminex themselves. So they've been good faith. They paid their rent, hoping that they would see change, and they have not seen change. We're still dealing with the same issues they've been dealing since June of 2023. I think it's not number one, and number two, I think it's unreasonable to ask for a back rent for the reasons the court. Not only that, the court rule doesn't allow it. 4.201. I-2 says it should be escrow, future escrow.
And just so that we don't have to worry about that, the only time that I ordered that's why I said it to extreme circumstances, I use what equitable powers this court does have over these cases to order that held. I don't see that here at this point.
So then at this point, I guess we're asking the court, and we have an order proposed pursuant to the lease. We're asking the court to order that the parties mediate. We have found out from University of Michigan, they can call their program now, they're happy to mediate, and they can do so. Very quick order, within a week or two, I think we could probably get in with them.
Within a week, really?
And we asked for mediation way back in September, and then Mr. Cassidy again in writing and asked for mediation on January 27th, I believe it was. So we've numerous times have asked. I think their position is once they hired an attorney, it means they don't want to. Which is ridiculous, and the lease doesn't say that.
Yes.
So I would ask the court to enter our order for mediation. Did the court want to address the other issues as far as consolidating the case and then the jurisdictional $25,000 issue?
I think my thought, quite frankly, was we were going to get it to mediation. Those issues were going to kind of be held off, seeing if it could be resolved at this level in mediation. that is how I envisioned when I left last week that this was going to proceed in that fashion. I thought everybody was on board with that. Okay. Is there anything else you wanted to say?
Just that if you allow escrow, prospective escrow, can we at least get an order for the payment for the unpaid utilities, electricity and gas that now are $3,418.78.
Look, folks. All right. I realize that there may be some financial pinches and strains. I get that. But every time I ask a question, I'm not going back to that issue. Just not.
So mediation is going to include the rent, the utilities,
It's going to include all issues.
and the court costs.
It's going to include all issues.
Okay, will you formally, do I prepare an order for you to sign about prospective escrowing?
Oh, it's just called escrowing, but can I see, have you seen the order prepared by Ms. Novak?
No,
My client said to me, right before court. So
Pardon?
this is just the order for mediation.
this
Yes.
is just the order granting mediation. So, I mean, we will sign this. We also,
No, okay, you need to understand something.
okay,
Well, I don't, I don't know what other courts do entirely, but if I'm going to order something, I'm going to order something and I'm going to order something else, but I'm not doing this. We will agree to this if.
we just need a little certainty
Certainty of what?
somewhere down the road. These people who have been underwriting their residence for,
Look, I have no reason, and that's what I'm talking about. I have no reason to believe that one party isn't going to do what they're supposed to do or that another party isn't going to. I don't have any basis for that. And I think I was indicating that to the parties the last time. I'm going to assume that people will act in good faith. It's really as simple as that. And so here's the other thing that I'm going to order. So hopefully we can make us more problem. I'm inclined to sign this order for mediation. All right. Do either of the parties have a time frame they believe for the length of mediation and timing? And what I mean by that is usually when we're sending, this one's going to be unusual, certainly. When we send cases off of the summary proceedings docket, I indicate that mediation should conclude in 45 days. The parties can then, of course, come to me and say, well, we're close to doing whatever. And so can we continue? And then I will make a decision as to whether or not it moves. So that's typically how it works. And so I guess do either party have a suggestion as to how long the mediation process should last?
I also talked with them, the University of Michigan, it's not on, what is it called? On site, on campus?
Off-campus housing program, which is what's contained in the lease, which is here. It may have some new name.
Right.
As long as it's whatever.
And I was told that, yes, we would be able to be heard within a week or 10 days. I would guess that if we set 3 weeks from today, and then if mediation is going well and we need more time, we can come back and ask for that. Or, come in and present the result of mediation.
All right, here's what I'm gonna do. Parties, I'm gonna sign this, we're gonna do two things. I'm gonna sign the order for mediation. The parties are to cooperate in mediation. I'm gonna add one thing to this order, and that is that mediation to conclude by, and I'm going to put June 21st, 2024, unless otherwise ordered by the court. So that's the first thing that I'm going to do, and I'm going to sign this order. So now this case is headed to mediation. I'm also going to enter an escrow order. In fairness to the parties, here's what I'm going to do. People can be upset with me if they want. I'm going to order that escrow will start May 15th. Okay. No, May 15th. No, it's okay. If you want to get up here and order, here, you want to. I'm just saying, if you want to do this.
It looks better on you.
So we're
You
going to
look good in
start
black.
escrow May 15th, which is going to then require that plaintiff post 2,000, if monthly rent is 4,000, you need to post 2,000 in the court escrow for the month of May. 4,000 would need to be posted for the month of June and each month thereafter that the matter is proceeding. Make sense? All right.
My question is,
Yes, ma'am.
utilities go month to month. I have given them the utility bills. Will we be able to escrow the utility bills? If they're going to be under mediation? Going forward, not going back.
Let me just ask this. Average utility bills per month, what utilities are included?
I included the most recent invoice, and
Well, I don't, okay, first question.
$340 was due on
Can you let
May
me get
1st.
my question now? What utilities are we talking about? first of all?
electricity and gas.
Is that all through DTE?
Your Honor, as I understand it, this is very odd again, the utility, my client's never seen the utility bills. They-
Oh, I've sent them all.
Requested.
I've sent them all.
He tells me they've requested them and they haven't even seen them.
They were sent with every invoice.
Yeah, I requested them in January, February. It's the first time I've seen them. Yes, we've seen the bills.
Okay.
I've seen cars.
So,
We need to see all the bills.
well, but hold on, folks. Yeah, I mean, and that will at some point happen. But it's just gas and electric.
Yes,
It's all DTE.
Yeah,
Right.
yes, DTE. There's no water, no sewer.
Okay. So then, are they, who's paying the water?
We, in the lease,
That the landlord's paying the water.
we keep them in our names so there's no transfer fee and to ensure that there's no shut-offs for whatever reason. And then I bill with the rent on a monthly basis,
Bill what?
the amount of the utilities from the past month.
Okay, and so what I'm asking is what utilities are you billing for?
Just DTE and
Okay, listen, just listen to my question.
I,
Water, no, just
No.
listen. Water is basically paid for by the landlord.
there is no water bill. We're on a well.
That's all you needed to tell me. You're on a
Okay.
well and septic,
Yeah,
right? So there is no water.
that's what I said. I did say that at the beginning. There's no water and no sewer.
Okay. And apparently I misunderstood. All right. So the only utilities, let's just boil this down, folks. The only
Yes.
utilities are DTE. Every utility that would need to be paid for by the tenants is DTE. Okay, so. And I don't have a problem escrowing part of, or the utilities. However, what's the average utility?
The average utility bill when they are in residence is about $340. 320, 363. That's the last 3 months. That was ending 4/9 and due 5.
Okay, all right, but here's the thing.
Okay,
And this is gonna be part of what the problem is. I'm assuming these bills go up in the winter.
yes, we do not pay a budget. We pay as they occur. But it's AC. So, the heat in the winter offsets the AC in the summer.
Do you have the utility bill amounts for the last 12 months?
Yes,
Okay. So with those bills, what's the average?
I don't have.
You don't know. All
No,
right,
no, no,
so-
I know I've got the total and I can divide by 1, 2.
What's the total?
5,
What's the
6,
total over the last 12 months?
11 into 2,571. $230, $240 a month, average.
What'd you just do?
I just divided the total.
Give me the total amount that you have right there of what you're saying the
Okay,
bills
the
are.
bills that have been unpaid are $2,571.64.
Okay, great. And that is over how many months?
11.
Give me
$233.79.
233.79. Okay,
We dispute that. They paid some of them. I don't dispute that number. I would also remind the court, the
Well-
landlord has $7,000 in security deposit.
no, I know, but I'm not even to that. They're not out, so I can't deal with that at this point. Well, hold on. I'll get to that in a minute. Jeez. Okay, I'm not gonna do it this way. I'm not gonna do another divide. I'm just not. So if somebody wants to appeal me on that, they appeal me on it. I'm gonna order that you are going to pay that 233.79 into court escrow for each month. You're gonna pay that full amount for May. Okay, I'm not gonna half that. I just.
Okay. So it'd be for May, it'd be $2,233.70. You said 79 and
Yes.
79 cents. And then for May, it'd be $4,233.79.
I think you mean $233, not 2,000.
No, 2,000 is
No.
the rent for half of
Yeah.
May.
Oh, sorry.
Right. Got it.
Okay.
That's what I did.
Yep.
Okay. So that's what we need to be deposited. The rent or the escrow for May, you'll need to do that within 7 days of today. And then for June, it's 7 days from when it's ordinarily due, but it will be due by the 7th of
7th
each
of
month. Okay? All right. Yes.
Can I ask that you add that this continue monthly until order of the court? So that if we have to go mediation
Okay, the
longer?
way the escrow order works, it continues
Okay.
till this matter concludes
you.
or until I say
Just-
whatever.
Just,
That's the way it works. You understand that, sir? You'd have to continue to pay.
If we're here in 2027,
No.
you still got to pay it.
God,
Okay. Then I'm going to give a control date on this for the parties to come back. If there's no further requests from mediation, so mediation basically would have to conclude without anything else by June 21st. I'll set this for a hearing June 28th, 2024 at
3 p.m.
3 p.m. Yes.
I can't make that. I'm celebrating my 80th birthday up north with my family. And we start on the 27th.
Okay.
So if you make it earlier, that would be all right, because I
Well, I
think,
don't want it earlier because I do it on Fridays.
oh, okay.
And so the 21st,
I'm here July 5th. Will July 5th work?
That's the Friday after the 4th. Yeah, I'll be here.
That's why it's the 5th. Yes.
I'll be here.
All right. What time?
I don't have a time yet. Well, it's the week after, so 12.
12. July 5th at 12 noon.
Thank you, Your Honor.
Okay, now let me try to address one other thing, and I really want to make more issues than we have. There's a $7,000 security deposit. Why is it 7?
Because they have permission for 2 dogs, and our policy is that we collect a dog security deposit of $500 for each dog. And so the security deposit for the rent is $6,000.
Okay. It might be an issue. All right. Pardon?
They're very nice dogs. I've met them.
Your Honor, we have one other issue that.
Oh,
Can we raise it?
no, you go right ahead. That's fine.
And what really brought it to our attention was a statement on mediation that Ms. Tope filed. She has really made herself a party to this and a witness to all of these. We are suing her individually for defamation per se. We're suing Ms. Tope. She's made police reports, false police reports against my client. And I'm seeing a possible conflict of interest pursuant to attorney ethics that will require her to not represent the Jeromes moving forward because she is a witness and also being personally sued. And so I don't know if the court wants that issue before us at this time, but it's an issue that I was alerted to this morning as I was reviewing for pleadings.
So I wear two hats in this situation. I am the landlord's agent in managing the lease. And that situation that I described occurred while I was performing my responsibilities in managing the lease. Once we had to file for, once the plaintiffs decided that they would file for withholding rent, they asked me to represent them as an attorney. So I think in all of the proceedings that are requiring the landlords to be represented by an attorney, the situation that occurred against me personally should have no bearing on my representation of them. That's denying them.
Okay. So the short answer, Ms. November, to your question is, I would like that. I won't address that today, but that would have to be raised by a written motion before the court, giving ample opportunity for Ms. Toth to respond. Counsel, I would, and why I think it would be best that it is in writing. And I'll just say this, and I don't have the answer to it, but I think what Ms. Novara in part is indicating, you both may be talking about the same thing in a lot of ways, because if you're acting in one capacity at one point and something occurs, and then litigation ensues, it may very well be that you were outside of any claim that might be made by the defendants in this case, that you may be a witness to the proceedings, and so may be in a position where you could not proceed forth.
And that I understand.
So, yeah, I don't, like I said, I don't want an answer to it.
No, I know.
Because I'm just saying that's the first thing that, outside of what Barbara was saying, that's the first thing that came to my mind after you finished saying what you were saying. So it may be right, but I think it's probably better if that be the case, that be put in writing right before the court. And then after you see what their issues may be, ethically, you may think, yeah, they may be right. Let me do X. Or you may say, no, I don't think they're right. Let the court decide whether or not it can be here or not. That's probably a much better way for us to proceed on that. All right, is there anything else? Seriously? Nothing? Okay. All right. Then,
Wonderful vacation. You said you were going to have a blast.
oh, I am.
Does it begin now?
The moment I walk out to my truck. All right. So, all right, folks, you guys have a great holiday and be safe, please. Ms. Novara, could you prepare an escrow order for the court signature? To the court, thank you.
How would I submit that? You know,
Yeah, you can actually email that right to Ms. Whiteley. All right. And it will get to me. Thank you.
yes, well.
Am I 14 days stands adjourned?